Kia ora, my name's Carwyn Jones. I'm from Ngāti Kahununu ki te Wairō, and I'm the kaihautu of Te Whare Whakatupu Mātauranga at Te Wānanga o Raukawa, and I teach into the Māori Laws and Philosophy program there. It's good to be back now that we've seen the final version of the bill. What the bill is doing is it sets out to redefine the principles of the Treaty of Waitangi, and so it sets out 3 principles that will then apply whenever the principles of the treaty are mentioned in legislation or arise in the courts in any kind of way. And what the bill proposes is that those principles will be put to a referendum. And should the bill pass and the referendum pass, then these will be the new principles of the treaty. So the principles that are set out in the bill, you can read for yourself to see the exact wording of those. The 3 principles that are proposed in the bill are essentially, first of all, that the government of New Zealand has the full authority of government and Parliament has full authority to make laws. And the second principle that sets out that the government says they will respect the rights of Māori under Te Tiriti at the time they signed it, but then it has this qualification and says, so long as they don't differ from the rights of any other people, except in situations where those are protected in treaty settlements. And of course, not only we have been through that settlement process and have a settlement agreement with government, and then the third principle is that everyone is equal before the law. There are lots of problems, I think, with the bill, and some of them are to do simply with the process, and the fact that, for example, what it's seeking to do is to redefine this treaty relationship without any consultation or engagement with the Māori side of that treaty partnership. And so that in itself is a flawed process and goes against the kind of relationship that's set out in Te Tiriti. The kind of key problem with the bill is that the principles that are set out in the bill are not at all a reflection actually of what's in Te Tiriti. So they present this false picture of what is in Te Tiriti. One of the ways that happens is when you're talking about that first principle, which is about the government having full authority and Parliament full authority to make laws. Well, that grant of authority in Te Tiriti, of this authority of kāwanatanga, is subject to the guarantee of tino rangatiratanga. So it's qualified by the fact that there will be a continuing Māori authority. And so the authority of kāwanatanga is not kind of full and absolute authority at all. It is constrained by the other guarantees that are in Te Tiriti, by the guarantee of ongoing Māori authority. The proposed principle 2 in the bill purports to recognise Māori rights at the time they signed Te Tiriti, but then says only if they don't, that they're not different from anyone else's rights. And so the difficulty with that is, again, that it's not an accurate reflection of what's in Te Tiriti, which was about specifically recognising Māori had these particular rights of tino rangatiratanga and authority. And so what is essentially happening in the proposed principle in the bill is that it's subordinating that authority to the Crown's authority. So it's only going to be recognised where the government says that it's okay, we can recognise these rights. And of course that's not what Te Tiriti says. Te Tiriti is a full guarantee of tino rangatiratanga. I think one of the real difficulties with this bill as a whole is that it's proposing a set of principles which are disconnected from Te Tiriti and claiming that they are grounded in Te Tiriti. Actually, some of these ideas are not necessarily bad ideas, but are protected elsewhere. So we have a human rights system and a Bill of Rights which protects people's equality before the law. So Te Tiriti is about protecting and guarantees to Māori specifically. Well, it's absolutely changing the meaning and application of the treaty, because the principles of the treaty is the main mechanism that law and government uses in order to engage with Te Tiriti. So if you're changing what those principles are, you are actually changing the meaning and application of Te Tiriti in our law. Wherever we have treaty principles in legislation now, there is Māori have a particular ability to hold the government to account for their actions. If this bill was to pass and these proposed principles were in place, that would effectively remove any particular rights recognition that Māori have in those spaces would mean that Māori wouldn't be able to hold the government to account through the court process in the same kind of way. For example, it removes a kind of mechanism that could help and has been seen to have been applied in areas like health and education, could help to address some of the inequities that we see there. But it also removes protections or levers that you can use to help protect aspects of our natural environment. And I think one of the key aspects that we've seen actually through the Waitangi Tribunal process and the claims process there is that has often put in place protections for our natural environment that haven't just been of benefit for Māori, but have been of benefit for all of us. The Waitangi Tribunal's jurisdiction would be completely narrowed, watered down, because their jurisdiction is based around the principles of the treaty. And the proposed principles are really saying that there are no particular rights that Māori have under Te Tiriti. And I think that's one of the most significant aspects of the bill, actually. One of the most problematic aspects of the bill is that it's saying, this agreement that was between Māori communities and the Crown and made promises and guarantees to Māori is now being redefined in a way to say that there are no particular guarantees or protections for Māori. And I think that's a fundamentally assimilationist way of approaching human rights and rights recognition. I think one of the most important things for the submissions on this bill is to demonstrate that the vast majority of New Zealanders do not want to engage in politics of fear and division, but most New Zealanders want to act in ways which are fair and just and develop good relationships across our different communities. And so I think that's going to be the most important thing to get across in these submissions, because in some ways the technical detail, the government's already shown that the technical detail doesn't really matter to them. They've had official advice which has pointed out all the technical flaws through this process. But the one thing that we know that politicians do always respond to is the politics of the situation and thinking about where the support lies. And so I think the most important thing through the submission process is for us to demonstrate that this proposed bill is not something that the vast majority of New Zealanders want.